that applies related to where you're coming from. So today we're going to get that discussion started regarding that. And because Kendall and Sarah both have great experience with particular companies, without actually disclosing them, I'll leave that to you. So let's start with this. So let's start north of the border, because north is the closest one to the Canadian border. I mean, to the to the U.S. border. Sorry, did I say the border moved? No, I'm sorry, it didn't. It's there. So obviously, Kendall, you've had some experience with the Canadian side, and tell us how that's been. Tell us what the companies had to deal with in order to meet those regulatory obligations in that jurisdiction.
Sure. Well, I mean, from the basic standpoint, you have to be a US or a Canadian company to use Regulation A. What does that mean? I know Sarah and I both have a lot of thoughts on that, because there's not a little book you pull off the shelf back here that you open up and go, this is what it means. We have to base it on what the SEC has told us over the years. We have to base it on precedent from enforcement actions and things like that. But one of the key elements that everyone needs to be aware of is that being a US or a Canadian company means that you have to have your principal place of business in one of those two areas, either the US or in Canada. And if you don't have your principal place of business there, then you can't use Regulation A. So that brings up the magic question of what is the principal place of business? And this, again, you can't just pull a book off the shelf. There's a lot of different interpretations about it. I've been through this battle many times with clients. Obviously, one of my clients that had no trouble with it is Brewdog. They had done the same thing as Regulation A in the UK over several offerings before they moved to the United States. All in all, the company has raised over $130 million from over 100,000 individual investors all over the world. But when they came to the US to do a Regulation A offering, they needed to be able to legitimately have a company that could do it in the United States. Well, it wasn't hard for them. They built a $30 million brewery with full offices, there's its own CEO, it's its own US subsidiary of the parent company. That's an easy one. That's a legitimate company with legitimate offices, with legitimate plant that creates a product, and all of those people are here in the United States. That's not a hard one. A hard one is something where someone comes to you and says, hey, all of my operations are in Italy. I happen to live in the United States. I'm the CEO. I'd like to open an office here over at the WeWork. Is that going to work? And my answer to them is no. It's going to take a lot more than that. But I'm interested to hear Sarah's experience too, because obviously she's dealt with this many, many times also. And it's always fascinating to me because I really can't find a bright line test that says this makes your principal place in the United States. It's always just a combination of factors. And I try to throw as many of those into the fray as possible to not have the problem.
Perfect. And I'm going to throw this one at you, Sarah, because this is so north of the border of the U.S. is Canada. You're right, and Kendall, as you said, the Regulation A is intended for companies in those two jurisdictions. But even from when you're from Canada, there's some little intricacies that are involved that, depending where in Canada you are, meaning what province, there might be some additional undertaking. And Sarah, I know you've been dealing with that with Canadian companies. What could you share to Canadian companies who are looking at this at the moment?
Yeah, I mean, the starting point has always got to be, if you are coming from Canada, talk to your Canadian lawyers, because one of the big differences between the two jurisdictions is that RegA that we're dealing with is a federal law, and there is no federal securities law in Canada. So there is no authority to say, whichever province you're in, if you do X, you get to not have to go through the registration or qualification or approval process, whichever it is in the jurisdiction. Excuse me. And so the starting point has always got to be, when you are coming from a province, and when I say coming from, you're incorporated in British Columbia. You need to talk to the lawyers that you deal with in British Columbia about what you need to do at home, because offerings from those jurisdictions, even if you're not offering in Canada, you have got to comply with the regulations in the jurisdiction that you're coming from. And then on top of that, as well as complying with the federal laws of Regulation A, if you want to be doing an offering in Canada at the same time, you're going to have to go through the sort of piecemeal of Canadian legislation and regulatory issues to make sure that you comply with each jurisdiction, each province that you're offering in. So in some cases, you're selling to accredited type offering investors only, and sometimes you're using a private placement memorandum. In some places, they actually have crowdfunding, and that might fit. So this is one area where, sometimes you can criticize the US for being so damn complicated. Now, it's more complicated in Canada right now. With respect to, I just wanted to loop back to one of the questions that I see in the chat here, and I saw it raised earlier. Why Canada? It's not just because Canadians are nice. We love Canada and you're so polite and everything, and that's great. But there is a long-standing relationship between the US and a long history in which US securities laws have treated Canada differently. For example, the multi-jurisdictional disclosure system that I worked on when I was back at the SEC a million years ago. The general idea was that there would be some way that you could register with the SEC and with the local authorities in your own jurisdiction. And we started with Canada because Canada has always been treated differently, because it's closer, because there have been memoranda of understanding with respect to enforcement of securities laws between the two. There is, they are members of the North American, Canada as well, securities administrators. There's always been a tight relationship. And to give a bit of really weird history, you know who else used to be treated the same way as Canada? Was Cuba. That was a while ago. A bit of weird history, but that's the reason why Canada's always the one that it's sort of easiest to loop into, because the rules are the same, the attitudes are the same. There's multi-jurisdiction, there is memorandum of understanding with respect to the relationship. And so that's why Canada, but if you do come from Canada, if you don't make an offering in Canada, it's super easy. If you do make an offering in Canada, super complicated, because you've got to go through each jurisdiction. There's no state preemption as there is in the United States. And just to,
it just does make it great to have that comprehension, because whether you come from Alberta or Ontario, it's not just an automatic shoe-in to use the regulation. There's a way to get in, but you need to deal with your Canadian side first. So for those who go, hey, I just need an American lawyer, I need to be very clear to everybody here that Sara, Kendall, and the many others need to speak to your legal party on the other side, because they need clear direction as to what exemption are you going to use in Canada if you're going to sell securities, or you're going to bypass them. Now, this is really important. This is if you are a Canadian company. It's quite the opposite, as Kendall has discovered, when you're an American company coming into Canada. Kendall.
Well, I just want to echo, both of you said this, but it's incredibly important that people don't forget this. You need to get advice from other country lawyers in other countries where you're going to be dealing with their securities laws. Obviously, I'm licensed here in the United States. I'm not a Canadian lawyer. I'm not a UK lawyer. And yet my biggest client is a UK company at the parent level. But I bring this up because something really interesting just happened in the last, literally in the last month, that it's the first time I've had to deal with this. Brewdog decided that they were going to launch a marketing campaign for the Regulation A that's going on here in the United States right now, with their offering that they just launched in the UK at the same time. And they just built a brewery in Melbourne, Australia. So now they have 4 breweries, one in Germany, one in the UK, one in the United States, and one in Australia. And Australia has a equity crowdfunding law. The UK has an equity crowdfunding law, and obviously we're dealing with Reg A here. So there's some very interesting byproducts of getting together with an Australian attorney, securities attorney, a UK securities attorney, and the US counsel sitting together and talking about they're marketing this in many cases all the same way. You're investing in BrewDog. Well, we have to be super careful that when people come to the US, they understand they're investing in BrewDog USA. They're not investing in BrewDog in the UK or BrewDog in Australia. So companies that have these types of international scope where they are raising capital across borders and doing these things, which almost every Regulation A company is raising money across borders. You need to be very smart about getting advice from counsel in the countries where the offering is being promoted to make sure that you're doing things the right way and following those laws also.
Yeah. And I'd like to add to what Kendall just said with respect to offerings into the other jurisdictions, because this comes up again and again and again. I mean, most of these offerings are online. People all over the world, I mean, the internet goes everywhere. And so you've got people emailing from Bulgaria or Rwanda or somewhere saying, can I invest? And we've sort of worked out the whole world in sort of a series of risk analysis, because there are some countries which will only bother about whether you're selling into their country if you do what I think it was Mark Roderick on the previous panel, if you actually actively solicit. And that includes like most of Eastern Europe, some parts of Western Europe. There are some countries who really don't care one way or the other. That includes some Asian countries. And then at the top of the list of do you really want to do this, is to use an intelligence term, the 5 Eyes. US, Canada, New Zealand, Australia, UK. Those guys are really fussy about what you do with investors in their jurisdiction. And at the top of that is Canada, because we have been in the very early days of Regulation A. One of the companies we were working with did an offering and took money from people in Ontario. Did not solicit, did not market, did not send anything, neither they nor the broker they were working with sent a thing into Canada, especially Ontario. Ontario said, you took money from investors in our jurisdiction. We count that as selling into our jurisdiction. Where's your exemption under Ontario law? And we're like, huh? And the upshot was the issuer had to give the money back to everybody who invested from Ontario. Now, we have heard, and I know we've had this conversation, Oscar, that maybe the Ontario authorities are not so bothered when there is a FINRA registered broker-dealer in the loop. We haven't seen anything official about that, and I would note that the guys who had this experience did have a FINRA registered broker-dealer in the loop. And so a lot of the, do you need to do something in a foreign jurisdiction is going to depend on, are you taking money from people in risky countries? And the risky countries are the ones who are super enforcing their investor protection laws. So, it includes the 5 I just mentioned. So one of the things that I was also mentioned on the panel was the slogan that everybody uses, all of the platforms, all of the issuers using at least our base subscription agreement says, by investing in our company, you are representing to us that it's legal for you to do this. Now, does that help? 2%?
Just 2%.
It doesn't hurt, but you cannot put the burden of regulation on the person who is the protected entity under securities law. Yeah, it doesn't hurt, but it's going to help you like, yay much.
It's been interesting. So just for everybody who's listening in, one thing about that this discussion kind of goes back and forth. So there's one, you being the entity itself and where you come from. That's one part. And then part number two, where the investors come from is part two.
Yep.
And sometimes people get them confused with the other. But the one question that always comes up, and I know that you brought up an example, Kendall, regarding Brewdog, who have been exemplary. I mean, they are the shiny light that everybody looks forward to for RegA because they're private, they're staying private, and they're growing their business. And I love their name for their shareholders, Equity Punks, right? But the question I get often asked, oh, all I need to do is set up a company in Delaware, Arizona, Wyoming, and all that. And obviously, it's not just about that. And I know in the past we've asked this question that are you going to expand into the United States and that's why you should be here, or are you going to operate in the United States? So can we talk a little bit about, because there are a lot of people, I mean, look, we have 47 different countries, 43 different countries here. So they're looking to, what do they need to do? Do they need to immigrate? Do they need to apply for an EB-5? Or do they just need to simply find people, set up a shop, and start operating in the United States?
If I had a dime for every company that's contacted me that said, I just want to access the 300 million people who are investors in the United States, but I don't want to do anything else, I'd have a lot of dimes. But the reality is, if you're going to use Regulation A and you're a foreign company, you're going to have a legitimate business purpose that's going to make some kind of sense to the entity you're going to have to set up. And sorry, I'm talking like a lawyer. Let me give you a more realistic. Let's say you're a manufacturer of some product and you're based out of Bulgaria and you want to access the US market. Maybe you're not selling any of your products here in the United States, but you want to expand into the United States and get your products into the stores here and have consumers buy your products online. It may make sense for that company to set up a subsidiary here in the United States. They set up a wholly owned subsidiary of the Bulgarian company, and that's the entity that goes to the SEC and says, we're going to raise money. Now, when you do that, you're going to have to explain to investors here in the United States what they're investing in. You're investing in a subsidiary of a company that may or may not be doing the kind of business that you're thinking of when you see the big parent company name. And the bottom line is, one of the ways that that's done is that you say, well, if we do any sales in the United States or in North America, or if we have any type of revenues that come from those areas, that's going to go into this subsidiary. That's why we're setting this subsidiary up. So a lot of this really isn't securities law. It's basic corporate law. There's a lot of accounting involved. There's a lot of tax law involved. These are very heady things that need to be decided by a company before they say, I'm just going to go raise money from the 300 million people in the United States using Reg A. You've got to have those people get a legitimate chance at a return on their investment through something that's going into that company. It can't just be a shell that you set up and all the money is just going up to the parent company for them to do whatever they want to do. Now, I say that if you do that, you got to tell the investors that's what you're doing. But the reality is, you want investors to have some reason to invest and some possibility of a return on the investment, and defining that before you get in front of the SEC is critical, because if you don't, I can assure you, you're going to get comments about it.
I was just going to say that, Kendall. I mean, the first roadblock you're going to deal with, not so much a roadblock, you're going to get the guidance from yourself, people like Sara. You're going to guide them, but they're going to insist, okay, put it through. The SEC will pick it up and say, okay, where's this money going to? If it's just simply going back to another country, I'm sorry, this thing is a no deal, no starter right there. And that's a good point. We get those questions all the time. Do I just need to set up in Wyoming? I'm ready to go? No. I mean, if obviously this is a phenomenal exemption, we have to take care of it. And it is available to foreigners. We have great examples like Kendall said, Brewdog Breweries. We have Elegant brand. Sara, you have Sagoon, which is an Indian-based company, right?
It's a US-based company.
US-based company. My apologies. Okay, but there's an example of he does his development offshore. My apologies.
Yes. Yeah, that's an important point. I mean, there's 2 points about there's sort of the foreign connections that I'd like to make. And one is To the extent you're going to be, you want to form a subsidiary, as Kendall was saying, not only does it have to have something real behind it. If you are just doing it to access the investors here, the SEC is going to see that money's going straight up. The SEC is going to say the parent is actually a co-issuer, and they are going to say, nope, as a co-issuer, it's a foreign issuer can't do it. And so that piece is important. There has to be a legitimate business here, which, and I see in the comments here, is different from Reg CF. Reg CF, we have seen this. You can just form a company here and everything can be offshore. That is not the case in RegA. The SEC is going to expect the primary place of business to be here. And to loop back to something that Kendall had said earlier, one of the things that I've always found very useful is the SEC's definition of foreign private issuer and the role that executives play. So, when you're looking at the definition of what is a foreign company, it includes if you have more than half of the executive directors, and there's a lot of definition about what executive directors are. If they're offshore, you can be a foreign private issuer. So you reverse that and say, well, if that's the case, you need at least half of your executive officers to be onshore. And we have had that conversation with the SEC. It's like, where is your CFO? He looks like he's all over the place. And we were able to say, well, actually, he's just down the road in Arlington. And he's legitimately there working out of his garage. But those are two very important points, is you really do have to have the management here.
Hey, Oscar, can I add one thing?
Please, please.
I'll come up to a comment. It's interesting that when you actually go through this process, obviously Sarah and I, we advise people as to what to do, but there's other professionals that are involved along the way. In many cases, there's a broker dealer. In many cases, the broker dealer or a third party is doing due diligence, much like what CrowdCheck does. And then there's an auditor, someone who's actually auditing the financials. And somewhere along the line, one of those three people is going to raise a red flag if you have a company that is complete BS, that is just a shell, and the money is going to the other parent company. Someone will be raising their hand going, there's a problem here. You're going to catch it in that process generally. At least know before you file with the SEC there may be a problem. So I only say that as a cautionary note to people. Don't think you can BS your way through this and that you're going to manage to somehow get it through the SEC because they're asleep at the wheel. There are literally going to be so many checkpoints along the way that it's just not going to happen. Just do it the right way. Do it the right way. It's well worth it. I think, Oscar, your microphone's off.
Oscar.
Oh, sorry. Sorry, my little baby. I don't want you guys to hear it. But you know what? It is COVID-19, so you're going to hear the sounds of my 5-year-old coming in and saying hello to everyone around the world. What I was going to say is, Sarah said it best. Just because in Reg CF it allowed you, and I ran into this, is that I'm already here. I was able to do it, so I should be able to. It's a slam dunk for RegA. No, it's not. It's not even in the same bucket. It's a totally different experience. And back to your point, Kendall, that this is something companies need to take serious in their journey in doing a proper offering. And it starts with bringing everyone together, bringing the lawyers, bringing the broker dealers, bringing these critical regulated parties who are going to guide you, help you structure this properly so you can be fully compliant, not legal, fully compliant. I mean, legal is one thing, compliance is another. And, so corporate law is in one side, securities law is alongside of it, but securities law is the one that you don't want to get yourself into any problems with any of the regulators. So I'll start with you, Sarah. Did you have any closing comments that you wanted to share with us today regarding, for anybody who is a foreign company, what checklist they should have ready in preparation to speaking to lawyers like yourselves and Kendall?
Once you've gone past the initial, do you have a legit business here, managed from the US? Then it's very much like a US regular US company. And the closing point that I just wanted to make on this, because Regulation S was raised in the one of the previous panels, so I've had this question so many times, and it doesn't make any sense, which is, can't we use, for those foreigners, can't we use Reg S? And I'm like, really? You think that Regulation S means that the United States is saying, we are regulating in France, and if you comply with this, you comply with French laws. Does not work. I do not ever, ever, ever recommend using Reg S alongside with Reg A. It is too difficult, and I wrote Reg S, and it's my baby, and it is not recommended to use alongside Regulation S. I'm just going to leave you with that.
Thank you. I totally forgot to mention that earlier. Somebody had indicated that you could, but you educated me on that. She is one of the writers, so if anybody has any questions regarding Reg S, how it's been misused and misinterpreted, maybe that's misinterpreted. And keep in mind that if I'm correct on this one, Sarah, this was brought in before Reg A, correct?
Oh yeah, it's been around. I mean, giving my age away, it was adopted in 1990.
So that explains the reason. So Kendall, back to you, my friend. Obviously you've been a pioneer alongside with Sarah. So what do you? I mean, you've been dealing with a lot of foreign issues. You're never afraid of them, which is great, because it's always good to have friendly lawyers who will take them on. What kind of things can we tell this audience right now to be prepared, to be ready, so when they come on to you to have that discussion, it can be a fruitful one for everyone?
Sure. Well, first of all, I was born in 1990, so I don't know anything about what Sarah's talking about. I'm just kidding. Just joking. One thing that I think is important is, and Sarah brought this up, and I think it's been in the comments, and I'm going to get very basic here for a very short period of time, because I think it's important for people to understand. Regulation CF and Regulation A are two completely different animals. They look to the consumer out there who's investing to be almost identical. You go to a page, you watch a video, you click a button, you pay with your credit card, blah, 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 blah. It almost looks the same. Behind the scenes, when you do a Regulation CF offering, you're filing documents with the SEC, but they aren't being reviewed or commented on by the SEC. You're just filing, and then you go and start raising capital. So having, this is one of the things, and I work with every CF platform out there. One of the things that bothers me that they do a lot of times is they'll tell people you don't need to have a lawyer involved. And believe me, I'm all for not having a lawyer involved if you don't need a lawyer involved. But you're filing a document with the SEC that the SEC isn't commenting on. They're not telling you you're doing something wrong. They're not saying, we don't like the way you have this structured. They're not giving you any of that feedback. You're literally relying on either the platform who helped you create that document or the lawyers you have to make sure that what you're doing is compliant. Whereas with Regulation A, if there's something you're not sure about, you file it with the SEC and they're going to comment on it, or if they don't comment on it, there's sort of in your mind, at least, it's not a legal presumption. It won't stand up in court. You can't say, well, the SEC didn't tell us not to do this. But there's sort of a presumption that, they're okay with it. Otherwise, they wouldn't have qualified the offering, meaning went through a review process. They asked you questions. You answered the questions. And then they said, you are okay to take this out to the general public and to the market and sell it. No one does that with Regulation CF, whether you're a foreign company, a US company, or what have you. So keep in mind, there is a big difference between saying, well, I did it with Reg CF and it was okay. It was only okay because nobody's complained. Or maybe you didn't do anything wrong. Maybe you did and no one's caught it yet. So the danger of just saying, well, it happened in Reg CF, so it's okay, I'm going to do it in Reg A, they're completely different animals. And you can't have that kind of attitude. You have to think through everything on both of these before you file them.
That's perfect. And in closing, I'm going to add to a comment you made that I think is important because I've seen it firsthand. And it's very clear to the audience. Yes, the regulators were kind enough to say the following: no, you do not need a lawyer to prepare the document. 2, you do not need a broker-dealer to sell the securities. You're right, that's what they gave you. But here is the realities. The realities is there's been no successful or an offering that's gone through this path that hasn't had problems. And today, they're likely for you to even execute, meaning getting an escrow provider, credit card, ACH, any of those services without a broker dealer is now becoming ownable. So the role of a lawyer and a broker dealer is to protect you. It's the best insurance policy as a CEO, board of directors you will ever have in your company. And it's such a small fee when you consider that you can raise up to $50 million. Seriously, I mean, look, I don't know any other country in the world right now that allows that. Every country is 5 million max, 5 million. I come from Canada. There is none. $250,000. That's your max in crowdfunding, depending. Yes, there's other exemptions. You can use a credit unlimited. No exemption exists like this today that allows you to raise up to $50 million from the general public within the United States and obviously other regions, depending you've done your work. And it's a free trading security, and you remain a private company. All you need to do is do it right. So Kendall, Sara, thank you again. If you want to reach them, go to www.KoreSummit.io, click on speakers. You can find their profiles, their contact details, reach out and begin the engagement. So I want to say thank you for them. We're bringing our next group in.